morning.
Good morning. I'm surprised you can hear in here. It's a little noisy.
It's not easy, and that's why we'd like to try to keep those doors closed.
Chair and Senators, thank you for the opportunity to present Assembly Bill 1685, a long overdue and common sense measure that updates California's civil penalties for mobile source violations. I would like to begin by accepting the amendment listed in the analysis limiting the stop sale provision strictly to the non-compliant product lines and not the entire fleet. As you know, the world's second largest automaker was caught and admitted to selling vehicles equipped with fraudulent defeat devices used to cheat emission standards. Not only did VW violate the public's trust, but its actions have had a negative impact on human health and the environment. These cars spewed illegal amounts of harmful smog-forming emissions into the air, contributing to California's worst in the nation air pollution. Senators, penalties are only effective when they are set at levels that ensure compliance with the law, deter future violations, and protect competitors that do abide by the rules. Penalties cannot simply be the cost of doing business. California's maximum penalty levels for violations of certification requirements, test procedures, and emission standards have not changed since they were first put into place in the mid-1970s, since 1974 to be precise, when cars and other equipment cost a fraction of what they do now. By contrast, federal penalties for similar violations are significantly higher and are periodically adjusted for inflation. AB 1685 remedies this discrepancy and strengthens California's ability to deter bad actors, meets its pollution reduction and climate goals, and protect public health and the environment by bringing our laws into the 21st century. I've worked with the manufacturers to address nearly every concern on their list. There remains one outstanding issue concerning the zero-emission vehicle regulations. I have proposed an amendment to the manufacturers to significantly reduce the penalty to $10,000 per credit, which simply adjusts the initial penalty for inflation. I will continue to work with the manufacturers to try and resolve this issue, and I thank you for your time and ask for an aye vote.
Thank you very much. Witnesses in support, 2 minutes each, please.
Thank you. Bill McGavin with the Coalition for Clean Air in support. I think this is the 4th or 5th hearing on this bill. And this morning, the federal EPA, Justice Department, and Trade Commission announced a partial settlement in the Volkswagen scandal. And it has some attractive features, but it also reminds us that there still is no approved fix for those vehicles. So we're still living with the excess pollution caused by Volkswagen. And it's a particularly egregious scandal that really reminds us that our enforcers and regulators need all the tools available to make sure that the cars that are actually driving around on our streets and highways actually do have emissions that are as low as they are certified to in the laboratory. So it's an important bill, and we urge your support.
Thank you very much.
Tom Addison with the Bay Area Air Quality Management District in support. 1975 was a long time ago. Penalties from 1975 that have not been changed since then are sorely in need of changing. This bill does that in a very positive way. Let me just make one additional point. Having significant penalties that deter bad behavior is important not only for public health, it's also important for the vast majority of law-abiding manufacturers. If their competitors can break the rules and get away with it with minimal penalties, that not only harms public health and the breathing public, but also those manufacturers who are playing by the rules. It's a good bill. We urge your support.
Thank you. Good point. Briefly.
Yes, Chair Bonnie Holmes-Jen with the American Lung Association in California. And just to note that the public health community and the American Lung Association are strongly behind this as a critical public health measure. And as we're entering the smog season and having smog alerts, and note that a lot of people are having breathing problems and rushing to hospitals and emergency rooms, and we need this bill.
Thank you.
Diana Vasquez with Sierra Club, California, in support of the bill.
Thank you.
Kelly Dillon on behalf of California League of Conservation Voters in support. Thank you.
Madam Chair, members, Brendan Tuig on behalf of the California Air Pollution Control Officers Association in support.
Thank you.
Jason Feifel on behalf of CalPERG in support.
Thank you. Any other witnesses in support? Witnesses in opposition? Well, that is a handful of papers. You get 2 minutes to cull all that down into a cogent, persuasive opposition statement. Good morning.
It's Judiciary Committee, Madam Chairman. I always come prepared.
Glad to hear that.
2 points. I represent the Alliance of Automobile Manufacturers. We remain opposed on a couple points. I was not quite clear on the amendment that Mr. Gomez accepted. I appreciate the fact that the stop sale should only be limited to the non-complying vehicles, but is it still a mandatory component of paying the penalties? As identified in the analysis, the statute says you shall stop the sale unless you pay the penalty. The penalty now could be 7 and 8 times as much. It's an extraordinarily unfair leverage if you can say your penalty is $1 billion and you can't sell any vehicles. What if you agree that the penalty should be, there should be a penalty, but only $500 million, not $1 billion? Are you prohibited from selling any vehicles during an appeal process? There's no mechanism of which I'm aware to appeal that which will now be 7.5 times as much. It's going from 5,000 to 37.5. So we need some relief there. All we're saying is it should be permissive. It wouldn't be prohibited, it would be permissive. The ZEV mandate. You heard the witnesses testifying in favor. This is to deter bad conduct. ZEV mandate is qualitatively different. We are required to produce and make available for sale vehicles, zero emission, plug-in hybrids, battery electric. If people don't buy them, why should we be penalized more? It's a qualitatively different regulation. And I have to say, circumstances are rapidly changing. They're deteriorating. We haven't had green stickers for plug-in hybrids since December of last year. And on June 10th, rebates stopped. So we've lost financial incentives. We lost half the non-financial incentives. How can we support an increase in a penalty for a violation of a regulation when the entire situation is rapidly evolving and I would argue deteriorating? So we need relief on that and we need clarity on the other.
Thank you very much. Other witnesses in opposition? Then we'll let the Assembly member respond to that.
Madam Chair and members, Ivan Altamura on behalf of Global Automakers. I can keep my comments short as they are aligned with Mr. Urban. I would just add that in regards to the penalties, that we believe that they should only be imposed after all appeals processes would be exhausted. So we think that mechanism is important to be made available. And I just can't stress enough the issue with the ZEVs and the penalties there and the conditions that exist, and for the mandate that we're under to sell these vehicles $1.5 million by 2025. And just to add another penalty on top of that is really going to hurt the industry to try to reach that goal. So thank you very much.
Thank you. Other witnesses in opposition? All right, let's bring it back. If you would like to comment on the concerns expressed in the opposition.
When it comes to the stop sell provision, if I wasn't clear, it is permissive for the ARB, and we shall be changing the shall to a may. So that is correct. We will be doing that. When it comes to the ZEV issue, the ZEV mandate was in existence before, we had the cap and trade, before we have GGRFs, before we had the stickers. It's something that it was actually passed in the 1990s at a $5,000 penalty fee. And even if you just take that into account, the penalty today would be slightly above $9,000, almost $10,000. So it is logical to say that increasing the penalty to a $10,000 level and not the original $40,000 is fair. In the end, the legislature made a decision based on the ZEV mandate back in the 1990s, and that was regardless. There was no cap and trade, there was no rebate. So we can say that that program was already in existence. So we're not here to debate the merits if we should have done that back then. We're just saying that the penalty should be increased to reflect today's costs. At the same time, you can't have a penalty, a ZEV mandate, that is less than the value of a car. Why? Because then they might come to a point where they rather choose just to pay the penalty than instead of producing the car. This is an issue that hopefully we can have a further conversation and get to a point that and an understanding that it's not punitive and we're not trying to penalize. I know there's some issues regarding cap and trade and some of the final budget, but that's outside of the scope of this bill. But I'm willing still to have that conversation and try to land the plane on this one last issue before the bill, if it passes today, before it gets to the floor.
And it is a due pass as amended to Senator Probst, so there might be some time to address it in that form. And I appreciate that. You know, part of it, there is sort of, I think, I won't say a knee-jerk reaction, but given what we've learned about the abuses that Volkswagen now is, I think the agreement is $15 billion, which is a substantial slap in the wrist. But if companies think that they can get away with these things or it's a cost of doing business, you're not going to discourage the bad behavior. And the goal here, I think, is to find a happy medium so that when a company looks at and does an analysis, they will decide that for some of us, we kind of wish that it was doing the right thing because it's the right thing, but recognizing for a lot of businesses, it's a question of the bottom line, that the bottom line doesn't pencil out, so that we can encourage that better behavior, the good behavior, simply because when you look at the profit levels, that there's a significant negative to trying to sort of fudge the system. And I'm not suggesting any of your clients have done that. I'm just trying to put this in the context of, I think, the public perception now. And I think that the Assembly members' comments and willingness to continue working on that, I think, is an appropriate compromise to that. So any other questions? Senator Wieckowski.
Can we have a distinction between, on the ZEV mandate, there's 1.5 or 1.5 million vehicles that you want to have produced versus a product being sold that doesn't have zero emissions? I mean, it seems like the thrust of the bill is if you're going, don't lie and don't cheat with the mechanics of what you're doing versus we have lofty goals and we want to achieve those goals, and I don't want, I'm serious about not having people fail because of some other market forces that they want. But it seems that the thrust of the bill is for people who put a product out there that alleges a zero mandate, and then some trigger goes off and it doesn't have zero mandates. Can you distinguish between this goal of volume of zero emissions versus a bad actor, I guess, that's going to falsify or trick the production of or the operation of the vehicle for the penalties? Or does it make any distinction?
Excuse me. Can I have one of the seats?
Could we have the opposition?
Go away.
Well,
we don't want them to.
We're trying to resolve the opposition, but if we'd let someone sit down and perhaps help answer that question.
But don't go away.
And there is still one other issue, by the way, the question about suspending penalties on appeal. I'd like to hear your thoughts on that as well. Would you like to respond to that?
Yes, I would. Kirk Oliver, Air Resources Board Legal Office. And the direct answer to your question is that the ZEV mandate is an emission standard, just like the emission standards that apply to fueled vehicles. It's part of the same strategy. It's just that auto manufacturers are allowed to comply with it in a different way by generating credits, and the credits are what determine the compliance or not. You're not going to have a situation where a battery electric vehicle is going to violate the tailpipe standards because they're zero. So it's about treating those vehicles fairly in the context of all of our emission standards, which are part of the strategy that we have to attain the clean air goals that we have to attain. But even so, there's been a carve out and a willingness to lower the penalty in recognition of some of the unique factors that pertain to ZEVs that don't pertain to the other vehicles. And where we stand right now is the penalty would go up double versus the way that it would go up in the other for the other violations, which would be many, many more times the base penalty that we have. So that's the direct question for this. You're not going to have battery electric vehicles that will have cheating done on them to evade tailpipe emission standards because there just simply aren't tailpipe emissions that come out of them. There are other technological requirements that apply to the ZEVs, but they tend to deal more with the durability of the battery and other aspects of the vehicle itself.
I'm going to interrupt for just 1 second. I've got to go present a bill, but I would like you to consider the situation with suspending penalties on appeal, recognizing that if the appeal doesn't prevail, that the fees should be incurred with interest so that we can encourage that as an option, but I'm just going to throw that out as an option.
And I don't know how those appeals work, so I'll let the...
Yeah, thank you. That's a great suggestion, and definitely something that we'll take into account. But you'll have to realize that the way that the bill's structured now, and any penalty process and any sanction for bad conduct, what that really does is it frames the conversation for when we find a violation and we bring the violator in and we attempt to settle it together, much like the Volkswagen settlement has gone forward under the context of the laws and orders that are available to the regulating agencies now. So let's talk a minute about how this might work. And the Air Resources Board finds a violation, they issue an order. Like any other government order, that is challengeable in court the minute it comes out. And we expect if we were not able to reach a resolution with the violator, that this thing would play out in court like that, where there would be opportunities to challenge the basis for the order and get into the substance rapidly. And the courts have the ability to do that.
But I guess while we have you here, it seems like the producers are saying we can't guarantee that people will buy the ZEVs. We can make them. We can beg for the green sticker program. We can beg the legislature for tax credits. We can hope that the price of oil goes to $10 a gallon. But we can't actually close the deal if the I drive here from Fremont through Benicia, and I see all those cars over there by the bay just sitting there. They can say, Senator, we've made $1.5 million, but nobody's going to buy it because the price of gas is 30 cents a gallon. It just doesn't, we see our mandate. I guess the question is I'm sympathetic to if we make the mandate, but the public doesn't buy it, why should these guys get a civil penalty? I mean, because technically they would not have met their fleet requirement for reducing emissions, because those are not on the market, right?
Well, 2 points to that comment, and probably the most important is that this would be a maximum penalty. These penalties are from 0 to 5,000 now, and the bill would place them from 0 to 10,000. That gives the enforcement agency the ability to craft a penalty in that range, and there are factors that are laid out in the health and safety code that the enforcement agency is required to take into account in setting such a penalty. So what you're talking about doing is taking a $0 to $5,000 per credit penalty and making it a $0 to $10,000 credit penalty. It's not making it automatically a $10,000 penalty.
And I guess for the opposition, the author has indicated that if we just did the cost of living adjustment from 1974, it's going to be $9,000 and some change.
From 1990 on the ZEV.
From 1990 on the ZEV to today, that if it had a COLA in it, it would be $9,000 and some change. So a suggestion that we'll go with $10,000, notwithstanding all the other mandates, would just bring us back to 1990, which might not be bad.
The ZEV mandate is assessed on the basis of credit, which could be 4 credits per vehicle. It's not per vehicle. So if we go to 10,000, it could be $40,000 per vehicle, which could exceed the value of the car. And I think that's confiscatory. It's not merely a deterrent. It's not punitive. It's confiscatory. But my point is this. The ZEV mandate requires us to sell 15% of new car vehicles in 2025 have to be ZEVs. We are at less than 3% right now. We are stagnating, if not declining, because of the price of gasoline. You're correct, Mr. Chair. Mr. Vice.
I'm nobody up here.
And because of the absence of green stickers and the absence of rebates. Why can the state abandon the public-private partnership and we get our penalties increased? Perhaps. I agree it's a 10,000. To me, that is just not good public policy. It's unsound and it's unfair in a time of difficulty to potentially double the penalty. For what behavior? Because we only offer leases at $99 a month? I mean, we'd have to give these things away to avoid the penalty.
We have two items. One is we have Congressman Brad Sherman in the room. So welcome, Brad. It's good to have you here. Two, Assemblyman Gomez, there was a hanging question that Chair Jackson asked about the penalty in appeal. Remind me that the suspension of the penalty, and we're hoping that you could conclude it.
Yeah, this is my closing statement. You want me to?
No, you.
Well, definitely, she asked if I would consider it. I'll definitely consider it. But it's right now, I'm kind of negotiating between the ARB as well as the manufacturer. So I have to get to a point where I can get both on board. If not, I can get an agreement on one aspect, get it to the governor's desk, and they don't agree with it, they veto it. So that's just the nature of this bill. But I would more than happy consider it and figure out if that's something that's possible within the confines of all the regulations and laws and the way that currently the processes work. But I'll definitely consider it.
Great. Any other questions, Senator? Would you like to make a motion?
I'll move the bill.
Okay, thank you.
This is the third committee you heard it in.
Assemblyman Gomez, would you like to close?
Yeah. Thank you, Mr. Chair. The penalties haven't been increased since 1974, it's true. And if we go all the way back to 1974, this is that same year that Richard Nixon, I've been saying this before, resigned. Jerry Brown was first elected to his first term in office. You know, the Pinto was one of the hottest selling cars at a little bit above $2,000. Gene Urban had black hair, and yours truly was brought into this world. So, you know, some things should be left in the past, and I think we need to increase the penalties to reflect our future. Ask for your aye vote.
Thank you. Madam Secretary, why don't we call the roll?
The motion is due pass as amended to Senate Appropriations. Jackson? Morlock?
No.
Morlock, no. Anderson? Hertzberg? Leno? Monning? Wachowski? Wachowski, aye.
All right, we'll hold the roll. We're going to go to item 17, which would be Assemblyman Holden. Okay. Thanks. Excuse me, Assemblyman Holden, I apologize. I know I give greater respect to those that are taller than me, and I apologize. We are all the way up to item 7. AB 1676. Assemblywoman Campos, it's your...
Thank you, Senator. I present to you AB 1676, a bill that would create a foundation to ensure pay equity for women across the state. Historically, in the United States, women have been paid less than men for the same job. California has one of the largest wage gaps for African American and Hispanic women who make 63 cents and 44 cents for every $1 a white male makes. AB 1676 will strengthen the California Fair Pay Act by making it clear that employers and to employees that prior salary cannot be used to justify a wage gap between men and women. This is a bill that I believe will continue to put women at an even playing field as they continue their careers, as they move on. I think it's an important bill for our young women who are entering at the age of 16 when they get their first job and especially when they graduate from college, to be able to be on an even playing field as they continue their career. I have witnesses with me. Oh my goodness. How are you? I didn't even look. Actually, this bill was, this individual that is next to me, Ms. Rizzo, is the reason that we continue to move forward in making sure that women have the same rights as men in the workforce when it comes to pay equity. And so I'm going to turn it over to her so that she can give her testimony.
Good morning, Mr. Chair and members of the committee. I thank you for this opportunity to share my testimony. My name is Aileen Rizzo, and for the last 20 years, I've worked in math education. I've earned 2 master's degrees and have worked very hard to try to break the stereotypes that a woman like me has to encounter. For the last 7 years, I worked for the Fresno County Office of Education as a math consultant. And in my 4th year there, I found out through an accident, really, that a male colleague that was just hired was going to make approximately $13,000 more than I was making. This made no sense to me for 3 reasons that I knew about him: that I had more experience, education, and seniority. When I went to HR, they informed me that the school contract I had provided to them in my application was not used to verify my employment, but was used to base my salary. It didn't matter how far back my previous salary was, they were going to use my prior pay solely to base my salary. When all of my internal efforts were lost and I could not resolve it, I filed a lawsuit in 2013. It was moved to the federal court, and this past January, it came before Judge Michael Seng for summary judgment. He awarded me summary judgment, and in his order, he made this very important statement. The court concludes that a pay structure based exclusively on prior wages is so inherently fraught with risk, indeed here the virtual certainty, that it will perpetuate a discriminatory wage disparity between men and women that it cannot stand, even if motivated by a legitimate, non-discriminatory business purpose. My employer has appealed, and my case proceeds now to the 9th Circuit. My parents sacrificed so that I can go to college, and I paid the same tuition as the males around me. Yet statistics show that women come out of college already making less than the males around them. I'm grateful for the laws that allow me to file my lawsuit, but my lawsuit that was filed in 2013 is still going on. It's not frivolous. It costs my family and I thousands of dollars in attorney fees that we are still paying. And I haven't seen 1 cent of the lost wages that I've experienced. And because of federal court's restrictions, I can only see 3 years of lost wages. I'm really doing this for women like me who don't have the opportunity to file a lawsuit, who feel like they're inside walls, that they can't continue to move forward and know that the man they're sitting next to is taking more money home to his family. So it's very important for me that I continue to just ask for aye vote in this very important bill on behalf of women like me, that we can close the wage gap, that we can be intentional for all women, and especially for women of color who have increased burden of low wages.
Thank you, Ms. Rizzo.
Thank you, Mr. Chair and members. Mariko Yoshihara with the California Employment Lawyers Association. AB 1676 is a very important clarifying amendment to the Fair Pay Act. We worked with Eileen and Senator Jackson last year on the Fair Pay Act, and we had Eileen's, what happened to Eileen in mind when we worked on the provision, the bona fide factor other than sex provision, which is a legitimate justification for a gender wage differential. It says, if you look at the language there, it says that the bona fide factor other than sex, the employer has to show that it was not derived from or based on a sex-based differential, that it's consistent with business necessity, that it's job-related. And so all those factors we thought would make it very clear that prior salary cannot be used to justify a wage differential. Now that the Fair Pay Act has been enacted, we've heard from a lot of employers after looking through their pay practices that a lot of the pay gap starts upon hire. We know because of this over-reliance on prior salary. We know employers aren't reading case law, even though a lot of cases have already established that prior salary cannot be used. So this makes it clear, spells out in the statute that prior salary cannot, in fact, be the basis for a gender wage differential. We think it's important for employers to really be able to have that in front of them so that they know how not to not rely on prior salary. So we respectfully urge your aye vote.
Thank you. Are there any other witnesses in support?
Good morning. Shannon Smith Crowley, American Association of University Women. We're a co-sponsor and ask for your aye vote.
Robbie Sumner on behalf of Attorney General Kamala Harris in support.
Morning. Aaron Lewis for the Consumer Federation in California in support.
Any other witnesses in support? Any witnesses in opposition? Any questions?
No, I don't have any questions. The witness with the employment lawyers clarified to me that this was still being used as a factor for the discrimination. I'll move the bill.
We have a motion. Do we have any? Well, I thought I saw Senator Hertzberg come in. Okay. Then closing remarks.
Senators, I respectfully ask for your aye vote.
Madam Secretary, let's take the roll.
The motion is due pass to Senator Appropriations. Jackson, Morlock.
Aye.
Morlock, aye. Anderson, Hertzberg, Leno, Monning, Wachowski. Wachowski, aye.
We'll hold the roll open.
And I have one more bill, if I may proceed.